and welcome back to another video. I, Shrishti Mishra, legal intern in LEXCLIQ and Company, is going to present today's video topic, that is Prevention of Atrocities Act, that is 1989. So, just moving ahead with the topic, it is very important to know that this video does not solicit any kind of promotion or advertisement under the guideline of Bar Council of India, and sole purpose of this video is only for educational purpose. Now let's get started with the video. So, this act, the Prevention of Atrocities Act 1989. This act was aimed at countering the multifarious ways in which the caste discrimination is placed out, and we talk about the which are the discrimination was done against them. So they were not allowed to move to temple, they were not allowed to pour the water from the same reservoir, they were not allowed to do anything, and they were not allowed to sit with any upper caste, with dominant caste, and practice of untouchability was done with high scale. So if we talk about at the present time, this all which I talk about is that years and years ago they were followed, but still now if we talk about the present day, still at some villages, town, these acts are still practices, not at a very large scale but at a minor scale, but still practices. And to abolish these and to prevent atrocities and aims at the hate crimes against ST and SC, and to safeguard their rights, prevention of atrocities were implemented. And this act, if I talk about this act is popularly known as ST Act and SC Act. And the objective, what is the objective of the government regarding that? So the main objective of the government was clearly emphasize the intention of the government to deliver justice to these communities and enable them to live in the society with full dignity and self-esteem, and without any fear of violence or suppression from the dominant caste. Now talking about the provisions of ST and SC, and rules can be further divided into three categories and covering the varieties of issues related to atrocities against SC and ST people and position in the society. So divided into further three categories, and first category talks about the provision of criminal law and penalizations given in the IPC Internal Penal Code. Second category talks about the provisions for relief and compensation for victims to atrocities. And lastly, the third provision is that provision that established special authorities for the implementation and monitoring this act. So if you focus on this video, I am taking this name, I am taking the term that is atrocity again and again. So what is the meaning of atrocity? So an atrocity, the term was not defined until this act was passed in the parliament on dated year on 1989, and expression is commonly used to refer to crime against ST and SC in India, and it denotes the quality of being shockingly cruel and inhumane, whereas the term crime is an act punishable by law. Okay? Now talking about one case, that is Subhas Kashinath Mahajan versus State of Maharashtra in the year 2018, that is 2018. And what happened that Subhas Kashinath Mahajan, what happened that he get arrested by the police officer, but afterward the investigation took place, no evidence regarding him was made out, no correct evidence, every evidence which was there was false regarding him, and due to which उनको जेल से निकाल दिया गया. What happened that he was bailed out. Now what happened that afterwards he filed a petition in Supreme Court, in which he told that the rights, the fundamental rights, that is Article 22 and Article 3 is violated. And looking at this the petition file, what happened that to looking at this matter, Supreme Court formulated some guidelines, in which the guidelines were by the Supreme Court that if any individual is arrested in atrocities case, then it must very must that inquiry investigation should be done by police before that person is arrested. पूरी जानकारी, पूरी investigation, पूरी inquiries must before arresting that individual person. Now another guideline regarding that was anticipatory bill, which is still applied. In this, what happened that if any person is arrested, he can take the help of anticipatory bill and anticipatory bail. But society did not accept these guidelines by Supreme Court. The society did not accept these guidelines, and with lots of border to central government, itna zyada pressure with the society, many rallies, strikes, many churches were going on news, and for this, what happened that central government got some changes in this act, in this guideline, that new section as article 18, section 18 was already there, and section 18A was implemented. That is, section 18A talks about the right to file, right to anticipatory bails, and section 438 CRPC provisions will not be applied in this act. And therefore, another change was made, that if any individual is arrested, he might does not take consult from his superior head. And what happened that the act that was before, जो ये changes लाने के बाद, the changes, the formulation that was, guidelines were taken out by Supreme Court, उसके पहले जो एक्ट था, उससे पहले जो एक्ट was, the act was the same before it is now. Earlier, after the changes made by the Supreme Court, the act was fully same as it was before. So this is whole about this topic, that is Prevention of Atrocities Act 1989. And if you like my video, go and smash the like button, subscribe to my channel, and till then, take care, goodbye.